All right. Hello, everyone, and welcome to our quarterly food and product labeling litigation and regulatory updates. I'm Trent Taylor, and I'll be your MC today. And as most of you know, we try to do this every 3 months or so to talk about new regulatory and litigation developments in the world of food and product labeling. Two changes from the usual for us. We have upgraded, and we are now on camera for the first time. A decision that I may be slightly regretting as I look even rougher than usual today, but we'll go with it. And the second sort of change that we have is our theme. And as most of you know, we typically try to have fun with this and have a little bit of a theme. And we came up with two themes for today. And oftentimes this time of year, we have a summertime theme. And, that's a little cliche, and we try not to be cliche. So we came up with two themes. Now, my original idea was not quite as good as the idea that Royce came up with. And so the first theme we have is today is the 95th anniversary of Miles Davis's birthday. I'm a jazz fan. I know that Royce is, and maybe some of our other panelists are as well. So we're going to be playing a little bit of his music today while we speak, to get in the mood. And I'll start us off with a little bit of music right now. The second theme we have is, as you probably know, every day is a national holiday for something. And it turns out that today is National Blueberry Cheesecake Day. Now, that's sort of lame, but there were slim pickings. It was either that or National Paper Airplane Day, and I decided to go with Blueberry Cheesecake Day. So we got a little bit of a blue theme going, and in that, consistent with that theme, we're going to give away a blueberry cheesecake and send it to one lucky attendee today. Now, don't worry, I'm not going to be the one actually making it. There's a bakery that does that, but we'll get in touch after the webinar with the lucky one. So let's get started. Everyone knows our panel. We've done this before. This is our all-star panel, and our panelists really are experts, subject matter experts in their areas. And we're going to be hearing, first of all, I'm going to start with a few high-level trends, and then Kate and Royce are going to talk about regulatory. Jenny Price is going to handle product labeling. Ben Abel will handle food and beverage labeling. And last but not least is Bethany Lukic out on the West Coast, who will be handling Prop 65. And then here's just a roadmap of what we're going to be doing. As always, if you have questions, feel free to submit them on the platform, or feel free to email us or call us anytime. We love talking about these kinds of things. We keep our finger on the pulse of what's going on, and anytime you want to chat or have a question or whatever, feel free to contact us. So let's get started. I'm going to start with some high-level trends that I'm seeing out there from 30,000 feet. And in doing so, I'm taking specific Miles Davis songs and trying to fit them into a theme, which is not easy, by the way. But we'll start with Freddie Freeloader, which I'm pretty sure is the name of a plaintiff's lawyer that I've met on occasion. And apparently Miles Davis has as well, since he named one of his most famous songs, Freddie Freeloader. And that's what you hear playing right now. But one of the things that I wanted to mention is the natural claims that are out there. And it is sort of cliche to talk about it, and we talk about it pretty much every single time we do one of these. And the reason we do is because they continue to happen. And we've been talking about natural claims for probably 10 years now. And these were really the first wave of the new food labeling claims, and it continues in part because there are still natural claims out there being made, and in part because the FDA has not really done much in terms of defining natural. Here are just a few examples of just, really in the last 3 or 4 months, some of these, last month of new class action claims involving natural, including some class certifications, some denial of motions to dismiss. So not only are they still being filed, they have legs. They're getting past motion to dismiss. They're getting certified as classes. So as always, and I know we say this a lot, but anytime you're using natural on a food or product label in any form or fashion, it is a high-risk claim. And this, you can see that borne out here by the litigation that is reflected on this slide. Trend number 2, and I'll switch to a new Miles Davis song, Blue and Green. And this is really about chemicals and greenwashing. I just want to touch on this just for a moment, because I know that Jenny will be talking about at least one of these cases here in a bit. But we continue to see a lot of focus on chemicals. And in part, that's because of the new Biden administration. There's a lot of executive actions, regulations, legislation relating to chemicals right now. And so there's that renewed focus is spilling over into class actions. Same thing with regard to the litigation against herbicides. And, we certainly know about the Roundup and dicamba and some of the rest of them, but there are new suits related to paraquat that are coming down the pipeline right now. And we think that will continue to spill over into class actions for products and food as well, where plaintiffs' counsel goes out, they test the products or the food at a lab, find traces of chemical residues, and then hook it up with a claim on the product, whether it's natural or preservative free or whatever it is, chemical free, and then file a class action based on that. The second part of that is greenwashing. And I know we've been talking about that for a while now, and I really do think we're really at the tip of the iceberg. That's sort of the next wave of food and product labeling, and I think we're going to continue to see that. And in claims like recycling or plant-based or ethically sourced, that kind of thing, we continue to see those lawsuits filed. So keep that in mind as well. Trend number 3, Deception, which is actually a song from Miles Davis, and I guess would probably be our theme song today as we talk about deceptive trade practices lawsuits. I don't want to talk very much about this one just because I know Ben's going to get into it and a lot more to tell, and he's really the expert on this. But there are a lot of flavor and ingredient lawsuits out there that have been filed, a lot from our friend Spencer Sheehan, who started with vanilla and has now moved on to some other types of ingredient and flavor claims, such as smoky, which is that first one there where a motion to dismiss was denied with regard to a label claim of smokehouse, because reasonable consumers could think the product was prepared over a fire in a special building. Okay. So then we'll talk about that a little bit more, but we continue to see a lot of those. And then my final trend is to one of Miles's famous songs, So What? And I just wanted to note that class issues continue to evolve, and that's for both good and bad. We obviously keep our finger on the pulse of what's going on with class actions, even when it doesn't involve product claims or food labeling claims, because it's going to affect it, right? And there have been some recent classes certified. There was one back in March related to breakfast bars or breakfast biscuits, and the claim nutritious. And the claim essentially was that it's not nutritious because it contains a lot of sugar. Those classes were certified. The Ninth Circuit just recently denied a 23F petition. The second thing I wanted to note is, though the dream of heightened ascertainability per the Carrera case from the Third Circuit is almost gone. The 11th Circuit finally did away with it recently. It's been eroded in a number of other circuits. So those are sort of bad for those in our space. But on the positive side, the Ninth Circuit and I think some other courts as well, they're not quite as class action friendly as they once were. And we've seen, I've seen at least 3 or 4 Ninth Circuit decisions in the last little bit that you're like, wow, that's a breath of fresh air. I didn't expect that from the Ninth Circuit. And I think we're going to continue to see that. And the last thing I'll mention just real briefly before I turn it over to Kate and Royce is that class action settlements are becoming more closely scrutinized. We've seen that in the 11th Circuit with incentive fees, and we've recently seen that in the, I believe, the 10th Circuit with clear sailing provisions. So I think it's going to be more difficult to get class action settlements approved in the coming years because of some of these developments. So anyway, that's what I wanted to sort of mention from a high level standpoint. And with that, I will turn it over to Royce and Kate.
Yeah, thanks, Trent. And here with my colleague Kate Hardy, who we work together on a lot of regulatory and FDA issues, and just drop right into the first issue we'll be talking about. And in my pompous jazz voice, which I really don't have, I'll say, this is off of ESP, Miles Davis' 1965 album. No, it's 81. It's a song off the ESP album. It goes great with really our first item here, which is Delta 8. What is Delta 8, and why are we hearing so much about it recently? And I promise you this applies to areas of food and dietary supplements just as much as it applies to, some of our more general cannabis clients. Delta 8 is one of many cannabinoids found within the cannabis plants, Rudialis indica or sativa. And it's gotten a lot of attention recently because of the proliferation of it in the marketplace right now. There's a trend amongst businesses and, attorneys who advise them that Delta 8 is somehow outside of the government's contemplation of what is a controlled substance and is therefore legal to be sold. And, Kate and I would urge caution in that analysis. It is not that straightforward, and there may be more leaning towards the risk of it not being legal than there is for it to be legal. And to that point, DEA recently added Delta 8 to its list of controlled substances in the Orange Book. And a lot of the ways Delta 8 finds itself, being sold is, either in corner stores or other places where it's being offered as a new, kind of alternative to CBD, another cannabinoid compound that is better than CBD or does something different than CBD. A lot of claims around it. Many states, in absence of clear direction from DEA, and there have been some indications from DEA that DEA doesn't like this and would most likely consider it a controlled substance, either through adding to the Orange Book of Controlled Substances or through its recent hemp guidance, which basically said synthetically derived cannabinoids are not permissible. Whether or not Delta 8 is synthetically derived is another debate in this gray area. But a lot of states have taken the position that we don't want Delta 8 being sold in our jurisdiction. They're banning or limiting the sale. Probably one of the clearest directions. So there's an absolute mosaic of legality, illegality, gray when it comes to selling Delta 8. And Delta 8 is finding itself into gummies, vapes, food items, edibles, and it's really just all over the place. And one of the biggest indicators that we have that this is probably not okay is coming from jurisdictions where adult and recreational marijuana is legal. And just a pause moment, those jurisdictions have a very vested interest in controlling the marijuana products that are sold in their jurisdictions and not having anything that can usurp the regulatory regime that has been carefully established in those states. And Colorado Med, one of the most, I would say advanced jurisdictions, most, aggressive enforcer of their marijuana regime in Colorado, came out and basically said on May 14th, super recent, chemically modifying or converting natural cannabinoids from industrial hemp is not part of the definition of hemp, and that applies to Delta 8 and Delta 10. So Colorado has taken a firm stand, even in a cannabis-friendly state, saying if you're not part of our program, if you're not part of regulated marijuana industry, you're not selling this in Colorado. Washington State's Liquor Control Board, another more advanced marijuana jurisdiction, has said Delta 8 can only be sold in regulated dispensaries. So the analysis is irrespective of the Food, Drug, and Cosmetics Act, which Delta 8 most likely runs afoul of because it's never been recognized as safe. It's probably an automatic adulterant to food. But we're also seeing that besides DEA, besides FDA, you have state cannabis regulators saying, not on our watch will you add Delta 8 to the general public's consuming of cannabis without actually getting a license and being regulated by us. So just something to think about when you come across Delta 8.
Bryce, I was just going to add in here too. I mean, there's been definite state level enforcement of this as well already. There's a couple states that have just gone into corner shops that are selling Delta 8 with CBD and seized everything. So it's definitely something to pay attention to, and we're definitely seeing enforcement there as well.
Yeah, that's a great point, Kate. It is being enforced, and we will continue to see it being enforced. Either, yet to see what FDA says, yet to see what DEA does, but we know the states are going after it. Next item, this is off of We Want Miles Davis, an album that was kind of, after Miles Davis's long break from jazz. This is a Fast Track, which fits really well with our most recent amendment to the Federal Food, Drug, and Cosmetics Act. An exciting occasion for anyone. It is the inclusion of sesame as a major food allergen. And that goes with, I don't know if I can name them off the top of my head, crustacean shellfish, seafood, pine nuts, tree nuts, all the allergens, dairy, the big ones that you should be aware of. Sesame is now part of that. Essentially means that sesame needs to be declared, scanned for, and monitored in products. I believe most people in the industry are doing that already. There just needs to be extra steps with respect to sesame. Would recommend you check your labels and make sure that if your product does have sesame, or you think that it might have sesame, that's declared on the label. And we can talk more specifically about the ways to do that offline if you want to reach out to us. But the other thing that the FAST Act did that a lot of commentators miss is it's really ramping up and lighting a fire under FDA and Health and Human Services to get its act together with respect to allergens and foods. And this is a multifaceted approach from Congress. It includes developing surveillance, which is code word for CGMPs, food allergen diagnostics, that's more on the medical side, but FDA and HHS need to develop ways to identify new allergen therapies, reduce the risks in the population, and all of this needs to be delivered to Congress in 18 months. So point of this is very much stay tuned to what's developing at FDA with respect to allergens. This is not FDA's foray into track and trace and, using distributed, digital ledger, blockchain-like technology for tracking food. That's all well and cool. This is more real. We really do think that FDA is going to take a firmer, more targeted look at allergies in the future and allergens in food products because they're being asked to turn in a homework assignment for Congress, which FDA certainly does not want to do during COVID-19, but will have to do, and a lot of attention will be given towards that. Oh, and the picture here is just from one of my favorite sitcoms. It's a scene where one of the tech founders of a company is laying out a whole bunch of sesame items to figure out whether or not he wants to invest in sesame. Great show, Silicon Valley. Would watch the episode. It's very funny. And Kate, I think this is, do you want to start on this one?
Yes, thanks, Royce. I am just going to very quickly run through an update on what's happening with CBD. I feel like Miles Davis actually did give us some nice titles. This one, I picked the song Voodoo Down for the CBD update. Not a lot of big changes to talk about here. Just to reiterate to everybody, we're still seeing FDA and FTC issue warning letters. There's been several fines. The newest update on the FDA side is one of the more recent warning letters that came out actually took the position that CBD can't be sold as an active ingredient in a product, in a pain cream. So this was a typical kind of pain cream that you might see on a store shelf. It was not promoting CBD as an active ingredient on the label, but the product can have CBD, and FDA took the position that all of that together was making CBD an active ingredient, and therefore they took issue with that. The other big thing that FDA has taken issue with is patient testimonials or any type of testimonial about the product. A lot of companies have done a great job with their labels. They're not making specific health claims, but they've had consumers make claims, this pain cream helped my arthritis, things like that. And FDA has also said that is not going to work. That's also labeling. There's been, again, another act introduced into Congress to try to help everybody with their products out there in the market, to allow CBD in food, beverages, and dietary supplements. We will see how that goes. And to Royce's point on the state law, there's still states enacting various types of laws that address retail sales, distribution, licensing, and labeling. So it's important, if you're considering getting into this space, to look at both aspects. And then I included Martha Stewart here because we do hear, well, Martha Stewart's doing it, so it's got to be fine. But that is not always the case. So just a quick warning on that. And then I'm going to, real quickly, the next area where FDA has recently cracked down is Kratom. That's another area where we get lots of questions. There's lots of products out there on the market. FDA recently seized a whole bunch of dietary supplements and bulk dietary ingredients containing Kratom, like CBD. FDA views there's no approved use for Kratom in any type of food or dietary supplement product. FDA, for the last several years, going back to about 2016, 17, has put information out there saying consumers should not take these products, but there haven't been heavy enforcement. But this most recent one, which happened in May, may be an indication of them moving towards more. And then lastly, again, like CBD, lots of state laws addressing these products. And with that, I am going to turn it over to Jenny, who is going to talk about product labeling.
Jenny, we can't hear you.
Sorry about that. I had double muted myself. Anyways, thanks for having me, guys. I am going to be running through some of the product labeling trends that we've seen, particularly since last February, or since this past February when we last presented. I was not clever enough to come up with a Miles Davis theme, so I give credit to both Trent and Royce and Kate on that. But nevertheless, the first theme we are going to talk about is particularly with product labels. And there seems to be a trend of, and this is not new, customers feeling like they've been deceived or told false information about a product based off of what's on the label. And particularly the last two cases I'll talk about are dealing with this greenwashing that Trent spoke about at the beginning of the presentation. But the first matter is a new case that was filed in the Western District of Missouri against Anheuser-Busch regarding its Lime-A-Rita, as well as its margarita, mojito, rosé, and sangria named beverages. The consumers are saying that the names of these are making it sound like these beverages contain tequila, rum, sangria, rosé, but they're really just flavored beers. I was particularly interested in pulling the label for the Lime-A-Rita just to see what it said. And it does, in fact, say that it's a malt beverage right on the label, right where you probably can't read it very well, but it's right under where it says margarita with a twist. So it'll be interesting to follow this case to see if malt beverage in that disclosure was sufficient to put consumers on notice. The next matter is, sorry, there's a little bit of background. The next matter is this GNC. GNC has been targeted in a nationwide and a New York class, stating that they falsely and deceptively sell triple strength fish oil because the plaintiff is saying that it doesn't actually contain fish oil due to the processing method that GNC allegedly uses. The plaintiffs are alleging that the essential fatty acids, EPA and DHA, are removed during that processing. And despite the packaging saying that there's 734 milligrams of EPA and 266 milligrams of DHA, doesn't actually contain those. There's not 1 milliliter of or milligram of either EPA or DHA. So that's one that we will continue to watch. And then as for the greenwashing claims, the two that I point out are one from against Hefty regarding its recycling bags. These are marketed by Hefty as being clear, so it's easy to tell the items in the clear bag are recyclable, and so it's, quote, perfect for your recycling needs. But the plaintiff alleges that the recycling bags are actually made of LDPE, which is a recycling contaminant because it can clog equipment and reduce the value of otherwise recyclable plastics. This is interesting as far as recycling goes because Pepsi, Coca-Cola, and Keurig Green Mountain are facing similar lawsuits regarding recyclable claims, claiming that their products are recyclable, and the plaintiffs are saying, in fact, they're not. So we'll continue to monitor that. And then another new case that was filed recently is a case against SC Johnson regarding its plant and mineral-based cleaning products that are sold under the name Ecover. Sorry, that's a hard word for me to say, apparently. The plaintiff had specifically bought dishwasher tablets that were marketed as being plant and mineral based, but she alleges they're chock full of synthetic, non-natural ingredients. She alleges a nationwide and California subclass, but also alleges that this is the case for about 14 other of the Ecover products. So we'll continue to monitor that as well. The next trend that we saw, I've talked about this a lot over the last, I'd say, year and a half, are these efficacy cases. I started talking to you, 2 years ago, maybe a year and a half ago, about the hand sanitizer class actions. Those are still going strong. One I wanted to circle back on are the Purell hand sanitizers. They actually won a motion to dismiss in the Northern District of the Northern District of Ohio. The court held there that plaintiffs had no injury and lacked standing. So that's a big win for Purell. I wanted to note that CVS is now being brought into the hand sanitizer efficacy class under the same sort of basis of the plaintiffs alleging that the claim that they're 99.9%, reduce virus and bacteria by 99.9%, or germs by 99.9%, is false because it doesn't actually meet that efficacy threshold. So we will continue to monitor that CVS case. And then another case that we told you about on the efficacy grounds is this molecule air purifier class action that was filed in the Eastern District of New York. That was recently sent to arbitration. So we will continue to monitor that, but I at least wanted to give you that update on molecule. One other area that we're starting to see some traction on, which again isn't really a new trend, but wanted to highlight these for you, are the product performance. So Samsung has reportedly been marketing its Galaxy S20 smartphone as having a rear camera that's professional grade, but apparently the plaintiffs are alleging that that rear camera spontaneously shatters, which has led to some personal injury cases. As the plaintiff pleads, they're seeking classes in New York, Ohio, South Carolina, Virginia, and Washington. So we will continue to monitor that Samsung case. And then finally, Apple has been recently sued over the performance of its water-resistant iPhones. Plaintiffs claim that Apple markets its iPhones as being water resistant, but then Apple denies the warranty coverage when the water contains either chlorine or salt. And sort of oddly, the complaint does not allege a specific class size, which is interesting. Finally, I wanted to talk with you guys about a series of deodorant cases. There are three that I wanted to chat with you all about. The Eighth Circuit recently affirmed a dismissal of a suit against Unilever for their Dove antiperspirant. The plaintiff alleged there that this is an example of a pink tax lawsuit that we've talked to you guys in the past about. But I really enjoyed some of the commentary that the Eighth Circuit provided in this opinion. The plaintiff had essentially alleged that the Dove women's antiperspirant she paid more for it than a similar men's antiperspirant that had, basically identical ingredients, and used this as an example of a pink tax, or, women paying higher for essentially the same product as a man just because it's being marketed to women. And the Eighth Circuit said that the plaintiff was conflating marketing targeted to women with enforced point of sale pricing by gender, and said that if the plaintiff was concerned with price, she could have bought the men's product. So I thought that was an interesting opinion from the Eighth Circuit affirming dismissal for Unilever. The next deodorant case is also a Unilever case. This is a type of sort of slack fill case that survived a motion to dismiss in the Southern District of California. You typically see slack fill cases in the food labeling context, but this is one that is in the deodorant category. And essentially, plaintiff is saying that Unilever sells Dove and Axe deodorant or antiperspirants in non-see-through packaging, and then has different price points for the different sizes, but it's not readily apparent based off of the size of the deodorant package that one contains more than the other. And so it's confusing to the consumer, thinking that they're going to get more product for a similar price. And the Southern District of California said, interestingly, that including the net weight on the label did not entitle Unilever to dismissal. So we will also continue to monitor that case in the Southern District of California. And finally, I wanted to talk about a class was certified against Tom's of Maine, which is owned by Colgate. And the allegation there regarded claims of natural deodorant and toothpaste, but the plaintiff alleged that those actually contained synthetic and highly chemically processed ingredients. The class was certified in 3 states as to consumer protection claims, but the court did hold that class was inappropriate for the express warranty claims because of the individualized issues. So we will see how those deodorant cases continue to play out. I will pass it along to Ben.
Hey everyone, this is Ben Abel. I am an associate in our Charlottesville office, and I'm going to go through some updates on food and beverage litigation, as well as some regulatory, but mostly litigation that we've seen, as Ginny mentioned, since we talked last in February. In the first is that, unfortunately, at least for those on the defense side of the V, we continue to see a number of the hits still being played here. And the first I wanted to talk about was flavoring suits, which we saw starting to get filed way back in 2019, and everyone kind of thought, "Wow, these are odd." And they started with vanilla, and we've seen close to 100, if not more, at this point, vanilla suits be filed. Largely by one group of plaintiffs' attorneys, starting in the eastern and southern districts of New York. And those flavoring suits have continued to grow and expand, both in terms of product, so expanding past vanilla flavoring suits into all sorts of different products that are flavored. As Trent mentioned, smoked products, so smoked almonds, products involving mint, products. Basically, if you have a characterizing flavor for a product and your product is not flavored 100% with that characterizing ingredient. So in the vanilla cases, the very classic version of the allegation was you have a bowl of vanilla ice cream that is flavored with natural flavors, but it's not flavored with 100% vanilla bean or vanilla extract. The allegation was that was deceiving because vanilla consumers, a reasonable consumer allegedly, would understand vanilla ice cream to only be flavored with vanilla bean or vanilla extract. Those suits continue to get filed. Different products that have no relation to vanilla keep being looped in. The most recent kind of aisle, or at least shelf in the grocery store, has been sparkling waters or seltzers. So a number of different SKUs and products and labels within the seltzer or sparkling water segment have been sued. So you have lemon lime seltzer water, but that isn't flavored only with real lemon or real lime, and therefore lemon lime seltzer water, sparkling water, is deceptive. These suits have also grown in terms of geographic scope. So we only saw them initially in the southern and eastern districts of New York. They then moved to California, which is the logical place you would think a food plaintiff would go next. But we have seen them begin to pop up both with that same group, cohort of plaintiffs' attorneys in places like Wisconsin, the Northern District of Illinois, which obviously is another popular place for filing, and some other jurisdictions. We also have seen suits that, at least by the pleadings, have not been filed by the same group of plaintiffs' attorneys. I have no idea if they're consulting or in a background role, but filed in Massachusetts. And so the geographic scope of these flavoring suits continue to grow. And all of that is at the same time that we have not seen, at least with judges actually ruling on these suits at the 12B6 stage, much, if any, success. We are up to, if not double-digit, at least high single-digit motions to dismiss being granted in the vanilla labeling suits, including a report and recommendation from a magistrate judge in New York that is currently up on whether the report and recommendation will be accepted. But almost uniformly at the 12B6 in one stage, the flavoring suits have been dismissed. Despite that, we have continued to see them be filed and filed and filed. And I don't know, to some degree, if that is just if you increase the number of suits that file, maybe one will hit. As is noted here, we have seen some settlements. Blue Diamond has recently announced a couple $1 million settlement. Califia Farms was another that announced a settlement. And so those settlements are happening, and there are at least some manufacturers in these spaces that have decided that instead of litigating the issues, they decide to settle. So these are still out there. And unfortunately, if you've got a product that has a characterizing flavor, and if that characterizing flavor comes from anything other than that specific ingredient, so vanilla bean in vanilla ice cream, lemon and lime in the seltzer water, the allegation is that that's deceptive. We haven't seen anything to suggest that that's actually true. It's certainly not how we read the regulations, and it's not how any judges read the regulations, but they are still out there. They are still prolific, and they are still happening. And so it's something that manufacturers need to be aware. The second that is much more recent, but is still dominated headlines in court dockets, are infant and toddler heavy metal suits. So as we discussed, I think the last time we met, a House subcommittee released a report about heavy metals and toxins in infant and toddler foods. And plaintiffs' attorneys were taking the products that were listed in that and then just basically attaching the House committee report to their complaints and not doing their own testing and filing those. And those continue to be filed. 13 Hanes Celestial suits were consolidated in the Eastern District of New York. It was not an MDL from across different districts, but there has been consolidation in the Eastern District. So we will likely see additional consolidation, if not an outright MDL at some point. This has caused Congress to act. The Baby Food Safety Act has been introduced in Congress, which hopes to set standards for heavy metals and other toxins in baby and toddler food. This also has, through a lot of pressure, caused FDA to say it's going to provide guidance on the issue. And the Attorney General of New York has started and is continuing an investigation related to baby and toddler foods and heavy metals and toxins in them. So to the extent you have SKUs that are in this space, these suits are still out there. They're still getting filed by plaintiffs, and there is increasing regulatory pressure and eyeballs that are being put on baby and toddler foods. The second is ingredient suits continue to see more success. And I think this is important because these often get lumped in with the flavoring suits we just discussed. I think in part because they are filed a lot of the times by the same attorneys that are filing the flavoring suits, and in part because in the flavoring cases, those attorneys have attempted to turn those cases into ingredient cases as a way to get past the growing body of 12b6 motions being granted and dismissing the flavoring cases. But it's kind of easy to look at the ingredient suits and say, well, they're being brought by the same people and are argued as being the same. And so they all also are meritless or something that we can look past. But they are having more success. The first of those is a suit against P.F. Chang's that was dismissed at the 12b6 stage of things by the district court. The Ninth Circuit reverse remanded. In that suit, plaintiff alleged that use of the word crab, spelled with a K, on P.F. Chang's menu was deceptive because it was imitation crab meat that was being used, but it wasn't described anywhere on the menu as being deceptive, or being imitation crab. And real crab, that was spelled with a C on the menu, was being used, and so that was deceiving to consumers. And the district court dismissed it and said, listen, if you see the word crab with a K, you should know that means that it's not real crab. And oh, by the way, if you're seeing crab with a K used in a California roll, which is a low-cost sushi roll where you would expect an imitation product, a reasonable consumer understands that. And the Ninth Circuit said, not so fast. We don't expect consumers to have that level, reasonable consumers to have that level of sophistication and detective work on their dinner menu. If there's real crab being used and fake crab being used, and they both are called out and it's just a letter change, that isn't sufficient, and the complaint stated enough of a claim to survive. And so that again is a case that doesn't deal with the flavor of the California roll, but rather what ingredients are being used. And the second is a honey graham cracker suit that graham flour or whole grain flour was not the predominant flour used in the cracker, and that honey was not the characterizing sweetener primary sweetener in the product. That again survived dismissal at the 12B6 stage, and that opinion was interesting because we've literally seen this decision go the other way, where judges have said, listen, a graham cracker is a flavor, and no reasonable consumer even knows that graham flour is a thing that exists, much less that it would mean anything within the name of a graham cracker. So it's not reasonable for a consumer to think they're getting anything that what tastes like a graham cracker when they buy a graham cracker. And this judge said, I also didn't know that graham flour was something until I read this complaint. But just because I didn't know what it meant didn't mean that the reasonable consumer doesn't know what it means. And as a result, I'm going to let this survive past the 12B6 stage. So these ingredient suits, while often I think are kind of lumped in our brains in with the flavoring suits, are a different beast and are having more success. And so again, especially the one vanilla suit that's gone forward is one where on the front of the soda it said "made with aged vanilla," and so where an affirmative statement of an ingredient in the product that was different than a mere "this vanilla ice cream isn't flavored solely with vanilla extract." And the third and final is that coffee just generally remains a hot, there's a nice food pun, hot topic in the food and beverage litigation space in a bunch of different ways. And the first of those is that, as we've talked about before, suits are being filed saying that the amount of coffee in a canister of coffee doesn't make the number of cups of coffee that the label of the product says or implies or otherwise gives instructions about. And as a result, it's deceptive because I wasn't able to make as much coffee as you said or implied or instructed me to make. Those cases have survived motions to dismiss. That was the Kroger case. They continue to be filed, which is the Demolis case. Folgers, J.M. Smucker has decided to put up a fight on these cases, and those cases have been sent to an MDL in the Western District of Missouri. On the other end of things, Maxwell House, Kraft Heinz, and Maxwell House and Yuba have settled for $16 million, including $3.9 million of attorney's fees. So two kind of segment leaders with very different strategies, but coffee serving suits are still out there. Obviously, if you have a coffee product with instructions or number of cups made, you want to double check that. Generally, if you have a label that says number of X within the package made, that's something you want to check. And then additionally, Kona, there was a suit from Kona coffee farmers in Hawaii saying that retailers and manufacturers were selling coffee that was not Kona coffee or was partially Kona coffee blended with other coffee that was being sold as Kona coffee. And those suits are still ongoing. Some have been settled for at least 6.1 as to some retailers, including label changes that will say the percentage of Kona coffee that is contained within the package. And so coffee products continue to be an area that plaintiffs' attorneys are looking at hard. So with that, I will turn it over to Bethany, and who will take us the rest of the way.
Thanks, Ben. So I think you've already heard about some action in our California courts, which is typical related to food and beverage labeling cases, and particularly class actions. And so I'm going to wrap up the day talking about Prop 65. And when we spoke in February, the main topic was OEHHA's changes and proposed changes to the short form label. It is no longer blueberry season out here in California. It's cherry season. Cherries are all over the farmer's market, but I stuck to the fruit side of our theme. And the big question is, are OEHHA's Prop 65 short form changes ripe? Are they actually going to go from proposed changes to reality? So just as a reminder, back in January, OEHHA proposed changes that limit when a short form warning can be used. It can only be used on now small products, or that's what they're proposing, and they define that as where the surface area is less than 5 square inches, or where the package size and shape can't accommodate a full-fledged warning. Food products can still use a short form warning, however, it has to be set off in a box. And the content has also changed of short form warnings. Short form warnings, as proposed, now have to include a chemical in addition to a specific pathway like cancer or reproductive harm. And so the other big change is that on internet and catalog advertisements, you can no longer use the short form warning. And obviously, this has been a huge topic for companies who have been using the short form warning, which for many manufacturers and retailers allows them to provide a pathway, but they don't have to become as specific as to the chemicals that may be, the listed chemicals that may be included in their product. So after a proposal like this is made, it goes through a notice and comment period. The notice and comment period was extended through the end of March due to COVID. There were 208 written comments submitted during the period. And if you're interested, you can go to the Prop 65 website, and you can read all of the various different comments that were submitted by a bunch of different industry groups, manufacturers, individuals, and the comments are sort of all over the place. At the request of Gorilla Glue, OEHHA held a public hearing on March 11th, 2021. There were about 20 parties that spoke at that hearing. And there were various different takeaways. One of the things that I noted in reading the initial statement of reasons, which was the rationale by OEHHA in putting this proposed language together, is that OEHHA commented that this change was not a significant cost change, that it wouldn't require manufacturers to do much. It was just a change in the label. And if you're a manufacturer or a retailer, you know how absolutely false that premise is. In order to make a change like this, not only could there be additional testing required, changes in your supply chain agreements, changes in all your labeling and manuals and things like that, which all take time, review, and to get into the pipeline, significant cost. And so that was a focus of a lot of the comments and a lot of the commentary, is that unlike what OEHHA concluded, there are significant and really real costs associated with these changes. Coupled with that was really the impact of COVID. Manufacturers, retailers have so much, or had so much on their plate, and I think continue to have so much on their plate over the last course of the last year during COVID, that this was something that, if added to the plate right now, was really going to hurt and damage retailers and really put additional costs and weight on them for very little change in what is actually being communicated to consumers. There were comments about the insufficient lead time, that 1 year, even after I guess, coast down time, for lack of a better word, after the Office of Administrative Law approves any sort of actual changes, that 1 year of manufacturing was not sufficient time to do all of these different changes. And there was also commentary that the driver of overwarning, which was the rationale of OEHHA of changing the short form warning to a long form warning, was really abuse of litigation. And I think we see that frequently. And I'll talk a little bit about that in when I get to the slide about 60-day notice trends. As you know, it is a cottage industry out here in California, and they go product group by product group and run all of the products through the test and hold many manufacturers hostage over various different tests for insufficient labels, a mistake in labeling, and often sometimes changes in manufacturing that have very little, if any, exposure to a consumer. And finally, the other sort of trend out of the comments was that the size proposals as to who can still use a short form warning, the 5 square inch rule, is really arbitrary, and that labels on products, particularly food products and smaller products, are already so crowded. And if you have to add all of this additional language and or set it off by a box, it's going to result in the consumer not reading the information and overcrowding on the product labels themselves. So what happens next? So OEHHA has an opportunity to review all of these different comments and then decide whether they want to move ahead anyway with their proposed changes, in which instance they'll issue the final rule and along with it the final statement of reasons, which evaluates and responds to each and every comment that is submitted, or they may choose to modify and or amend the proposed regulations. If they go with the modification or amendment, there is a subsequent notice period that follows and a second commentary period. And that cycle continues until OEHHA is satisfied that it wants to move forward with whatever proposed regulations. Typically, it takes OEHHA about 60 days to respond to comments that are issued along with a new proposed rule. However, we have seen instances, for example, with the 2016 larger changes to Prop 65, those went on for quite some time and really didn't get enacted for years. So I think this is a pretty controversial change. It comes on the heels of big changes to Prop 65 that have only, recently been enforced in the last couple of years. And so I anticipate that it may be on the longer side of things versus the shorter side of things. That isn't to say that if you are a manufacturer, if you are a retailer, that you shouldn't be paying attention to this issue, looking into your supply chain, really evaluating what potential listed chemicals you may have in your product and at what exposure levels those exist, such that you are ahead of the game if the final rule does come forward in some shape or form. And there's a year lag time by which OEHHA must submit the final statement of reasons, and that's January 8, 2022. Again, I think there is some leeway and some play in that, so I wouldn't even hold them to that date. And the last slide that I have to wrap up is just sort of what is going on in terms of the plaintiff's bar associated with Prop 65 notices. Many of you may have received a 60-day notice in the past. Under the statute, you have 60 days to basically deal with a plaintiff's lawyer to convince them to go away because you think your labels are sufficient or your product exposure doesn't fall within regulated limits. And it also gives the Attorney General 60 days by which the Attorney General might notify the plaintiff's counsel that either they don't have a claim and they need to withdraw their 60-day notice letter, and or that the Attorney General wants to move forward itself versus the plaintiff's bar as the sort of private prosecutor. So it's interesting always to look through those 60-day notices. You can see clear trends in the types of products that are being tested and the specific chemicals that are being tested. So amongst food and beverage products, there were lots of seafood type products that were listed. Again, cereals and snacks, baked goods, we had seen a focus in the past before the new regulations were proposed relating to acceptable levels in baked goods. Dietary supplements, there's a huge focus on dietary supplements, particularly with respect to things like lead, mercury, arsenic, cadmium, and spices. Again, things like lead, arsenic, cadmium that might occur naturally in soils and get picked up in various different spices are, again, a focus of the plaintiff's bar. When it comes to other products, again, plasticizers, anything that has a plasticizer in it. So any sort of bag, cover, case, makeup bag, sports equipment cover, phone covers, all sorts of anything that has some sort of grips on, tools and products, anything that has that plasticizer in it, that those are a focus because of chemicals like DEHP, DINP, BPA, and DIDP. Lead was a focus in some products that had ceramics involved, as well as products that had some metals associated with it. And then finally, there was and I'm trying to dig to the bottom of it, there was a trend where there were a lot of tool manufacturers and retailers who were targeted for wood dust labels. And if you read the wood dust labeling regulations, I'll be interested. Many of these have been withdrawn. I suspect the reason that they are withdrawn is that the wood dust labels really apply to wood products, and you would not consider a tool like sandpaper, like a saw, to require a wood dust label under Prop 65, because it's not that product that creates the wood dust. It's not a wood product. Those products aren't wood products as the definition exists in the regulations, but they are used and may create wood dust. So it'll be interesting to see where these land. I look to see if the Attorney General has been focusing or has commented on these 60-day notices, because there were quite a few out there, but haven't seen any. So hopefully the defense bar is just pushing back on the plaintiff's bar, and consistent with the statute are saying that these types of warnings are not required on woodworking tools and accessories. So that's what's happening in Prop 65 land. We'll continue to monitor this rulemaking with the short form, because it does have tremendous impact on all manufacturers and retailers. Use of the short form warning is very widespread. So with that, I'll turn it back over to Trent.
Yes, thank you so much, Bethany, and thank you to all of our panelists, and thank you to everyone who attended today. We greatly appreciate your attendance. If you have any questions, feel free to contact us. And with that, our webinar is now concluded. Thank you.